I could not reconcile with this bank why the short sale set forgave the debt, but the deed in lieu did not. I could not reconcile that. So the client filed bankruptcy.
And that left a lien on the property?
Well, he filed bankruptcy and then the bank foreclosed. He said you can have, he just let it go. It's like, if you're not going to help me, we're not going to help you. And they let it go. That was Bank of America, for the record. Yes.
This 35 Kings Highway, where is that in relationship to the library?
Down towards the train more. So the office is...
The other side of 70, right?
It's on Kings Highway. Yeah, that's what I said. It's not in Cherry Hill. You mean the Cherry Hill Public Library or
Yes.
Haddonfield?
Yes, it's the other side of 70.
Well, it's north of 70.
If you're going west on 70, it would be on the other side towards the Haddonfield.
Yeah, it's like the city part of Haddonfield where you can't park or everyone walks and there's,
Yeah.
there's a Saxby's and a Starbucks
And a train station.
and a train station. Yeah, exactly. It's right there. But there's the Haddonfield Public Library. You threw me off there, but yeah, still down far from that.
Would medical count as a situation of hardship? Severe medical costs and bills and whatever?
It could, sure. I mean, you know, medical by itself. You know, if I break my leg and I can't pay my mortgage, that's not going to work. But if I break my leg and my doctor's bills are $100 grand and I can't go to work and I'm on disability, that's a hardship, right? Because now it's not just the medical, but it's also the loss of income and increase of expenses that goes along with it.
Yeah. Okay.
Around the end, my last question.
Yeah, sure, no.
Around the end of last year, I got some emails, usually from mortgage companies, saying in 18, there's going to be a new federal regulation, 60 days, the banks are going to have to either approve, disapprove, or counter offer. Any truth to that?
So there's, you know, I can't comment on a federal regulation, but I can comment on a similar state regulation for New Jersey.
Okay.
So Governor Christie passed a law before, a few months ago. I guess before he left office. I think he's done now. Before he left, it's not that, it doesn't help us. And it says the same thing. And if you look at my short sale addendum, I had to actually alter it to reflect this new law. So it doesn't force the banks to give us, to approve or deny the short sale. What it does is it says that if we don't have an answer within 60 days, the buyer can walk. Right? How's that help us in any way? But here's the funny thing. It doesn't help buyers either. Because it doesn't say approval or denial. It says they have to have an answer, something back from them. That something could include a request for more information. So what happens, so literally, let's say I'm a buyer of a short sale, and the 59th day comes, and I haven't heard a peep from anybody. And then all of a sudden, the law firm sends out, the bank requested updated bank statements, which is something you hear a lot in short sales. That buyer can't walk under that new law. Because within the 60 days, there was an update from the bank, and that update was a request for more information. So it doesn't help anybody, to be honest with you. I've never seen a situation where I was able to force a mortgage company to give an answer in a specified period of time. It's never happened. And even if it does become law, the chances of them following it are rare. So just to give you an example, these FHA guidelines for the short sales, there's only one Department of Housing and Urban Development. There's only one set of rules. And they are enforced discriminately, like unbelievably different from every bank.
Okay.
Is there like, two questions, is there a minimum that you look for on a contract for a deposit? And if the buyer decides to walk, is there any liability against that buyer?
Sure. So, I mean, you want the deposit to be high enough so that at least there's some fear in the buyer that they don't. I want the buyer in the back of their mind to say, well, I really don't want it, but I don't want to lose my deposit either, so they proceed. Right, so high enough to install that fear, but the bottom line is, if they're breaching, no one's going after them. Who's going to go after them? I mean, let's say the deposit's $3 grand. Okay? So I'm representing them in a short sale. I'm doing so for free. I'm not representing them in suing the former buyer to get, for damages. It's not something I would do even if they were paying me. But what are they going to pay? Another attorney $3 grand to recover $3 grand? What are their other damages? They're not paying their mortgage, right? So it's not like they're paying carrying costs and going out and relisting and selling the house like in a regular transaction. Not to mention, do you really want to tie the property up in litigation? I mean, your goal is to avoid foreclosure, avoid mortgage liability. If those are your goals, then release them, sell it as fast as you can, let me try my job again. A lot of times people don't like to hear that, But as a practical matter, it's a better way to go. And I've had buyers, sellers who have disagreed, and they've gone after the buyers before, and they sue, and that's great, but they're never going to recover anything that's going to make a difference. I mean, it's not like you're doing a regular sale on a $500,000 home, where after the buyer breaches and every month that goes by, the homeowner's paying out $3,000 on their mortgage, and then they sell it for $10,000 less. I mean, those are damages. I have to imagine that insurance of the damages would be difficult to ascertain. Not to mention the homeowner would have to pay to go after them.
So essentially, if your buyer was to walk, like Tony's scenario, you just give them their money back and let them go.
If most sellers do that, yeah.
Yeah.
Most sellers will do that.
You're telling that the buyer walks.
Yeah.
Yeah, if the buyer walks and you give them
Trouble I
their money
have,
back.
always had is the mutual release has always been a pain to get that deposit money back.
Sure.
Because some instances, the seller has left the country or left the state, we can't track.
It's funny you mentioned that, because that's something different, because in that case, there's no breach by the buyer. The seller's MIA, right? The seller's gone. So, I've had this situation happen too many times. I mean, again, it's nothing on me, right? I'm not holding the deposit, but what I do is I put something in my agreement with the homeowner that allows me to sign on their behalf if they do that.
Okay. So you can sign the release
Yeah.
for the deposit money back.
Yeah, I have a limited power of attorney, and in my short sale addendum, I think there's something that says I can sign, certain documents like that, like an attorney review letter or a cancellation of contract if there's no dispute. And if the seller's MIA, I can sign on their behalf, get the deposit back. Like I said, I've had situations where the poor buyers, or even though they're not my clients, they feel bad they're stuck.
Yeah.
Because the sellers have
That's
disappeared.
been that's actually happens quite a bit.
I mean, the two ways around that are, one, letting me have that limited power of attorney, which is in my docs. Another way is to add another provision in the contract that states that in the event a contingency is not fulfilled, the deposit is automatically refunded. So, I've seen some attorneys put provisions like that, and this way, if the short sale is not approved, the contingency is not fulfilled, the deposit's released without signatures. Another way to do it, too. All right.
Thanks, Bill.
Thanks,
Yeah,
guys.
okay, so-